Okay. So this class will be on horizontal restraints, right? Basically collusion and cartels. And there are two topics, the capacitor and graphite. So who want to go first? What about by order of the time you uploaded the file?
Yeah. Sure. So it's the capacitor first, right?
I'm so sorry. Can we start over again? I was in the call earlier. I'm going to share a slide right now. Sorry, everyone.
Oh, you want me to share it for you? Oh, okay.
Okay, can you see it now?
Yes.
Yes, I can see it. Thank you.
Okay, so today me and Peva brought this capacitor manufacturer in Singapore into the discussions, and the problem is about price fixing and information exchange, and it was decided by Competition Commission of Singapore. And the background of this case is about these five manufacturers is Enna, Panasonic, Rubicon, Nippon Chemical, and Nishikon. And they are all AEC manufacturer in Singapore. And what exactly is AEC? AEC is the aluminum kind of capacitor that normally used in electric device such as computer to store energy. And what did these five companies do? From 2000 from 1937 until 2013, they held regular meetings to exchange confidential information and also commercially sensitive business information, such as customer quotation and sale volume. And they also discussed and agreed on sale price, and also including the various price increase. And they also agreed to collectively reject customer requests for reduction in price of AEC that sold to them. And also in the ruling, they state that in 2013, these five companies held 64% of the market share. And we will go to the market definition. Why do we need to find the market definition? Because the market definition serves two purposes in the context of an infringement decision relating to the Section 34 prohibitions of the Singapore Competition Act. And also, the market definition provides the framework for assessing whether an agreement or concert practice had an appreciable effect on competition. And the market definition also provides the basis for determining the relevant turnover for the purpose of calculating penalties under Section 69, subsection 2D of the Competition Act. And in this case, the Competition Commission of Singapore stated that a distinct market definition is not necessary in this case because the agreement, the practice involving in this case is price fixing, and it doesn't matter it is direct or indirect. The price fixing agreement always have the objects of restricting competition to an appreciable extent. And in assessment, CSS considered these following factors according to the CCCS guidelines on the Section 34 Prohibition 2016, paragraph 2.24. And the third factor that they consider is the content of the agreement, and the following is the object aims pursued by the agreement, and the last one is the context in which the agreement is applied. And if you focus on the object of the agreement, the price fixing agreement, you see that by its nature is always regarded as restrictive to the competition. And the CCS also use these objects of the price fixing agreement to define the relevant market. And they state that in accordance with the conduct of the party, the five capacity company, it had objects of preventing, resisting, and distortion of competition in the market for the sale of AEC to customers in Singapore. And I think this is pretty interesting that the CCS state that they don't need like a clear market definition when it comes to this price fixing agreement, and they will focus only on the objects of the agreement and use it to only define the relevant market. But in normal case that the case that do not involve directly or indirectly fixing price, or bid rigging or collusive tendering, and sharing market and limiting or contouring production or investment, CCS would use the hypothetical monopolist test as in the CCCS guidelines on market definition to define the market. And what exactly is the test in normal case? Because I think defining market is always essential when it comes to this competition case, and the hypothetical monopoly test it tries to identify all the products that buyer regard as reasonably substitutable for the focal product. If the product is identified, then the competitors that actually constrain the exercise of market power is also identified. The test starts with a narrow definition of the product and geographic market. And the step 2, they will try to raise the price of focal product by a small but significant non-transitory amount above the competitive levels. And step 3, they will ask, will a significant number of buyers switch to the next best substitutes? If no, the test ends right there. And if the answer is yes, the next best substitute are included in candidate product group or area, and they will repeat from step 1 again. And the other thing I want to focus is in the guideline on market definition, they also give the threshold level, like if the market share of the concert party is above 25%, then they will consider the practice as has the object of preventing or resisting the and distortion of the competition. But when it comes to the price fixing, or these four kind that I have mentioned earlier, that if when it comes to these 4 kind of practice, they will not give like the clear market definition. If the practice is directly or indirectly fixing price, or bid rigging, or sharing market and limiting or contouring production or investment, The 68 we also not consider the threshold level state in the guideline on market definition as well. And I think we can move on to the next part. Thank you.
Okay, so moving on to the issue in this case, the first issue will be whether the alleged actions, which in this case mean the meetings and the price fixing agreement and the information sharing between the 5 companies fall within the scope of Section 34 of the Singapore's Competition Act. And just before we move on to the issue, I would like to say that Section 34 basically prohibits agreements between undertakings, decision by association of undertakings, or concerted practice which have as their object or effect the prevention, restriction, or distortion of competition within Singapore. Meaning that the action of making an agreement or the action arising out of such agreement will still be a violation of Section 34 if the agreement has the object or effect in preventing, restricting, or distorting competition within Singapore. So it focuses more on the result of the agreements between the undertakings more than where the actions of making an agreement happens. So you can be meeting or collaborating in Japan, but if that agreements you make in Japan have an effect of preventing competition in Singapore, that will still be a prohibition of Section 34 of the Singapore's Competition Act. And in this, we can look at the CCS guidelines on Section 34 Prohibition 2016, and in this, we'll call it the Section 34 guidelines. GAME has also mentioned in guidelines on market definition, and I would like to note that these guidelines aren't actually have a legal binding effect. It serves more than a interpretative tool for the CCS when assessing agreements between undertakings, whether it violated Section 34 of the Competition Act or not. So CCS remains free to set its strategic priorities and consider each case on its merits, its facts and circumstances. So it is okay for a CCS to deviate from these guidelines if there is other facts and circumstances particular to each case. So that is important to note. And when the agreement or the concerted practice mentioned in Section 34, CCS mentioned in its decision that it is not really necessary to characterize the conduct in this case, whether it is an agreement or a concerted practice. A single infringement of Section 34 can be both an agreement and a concerted practice. This is also mentioned this case SA Hercules Chemicals and Commission, which is an EU European case, which set these principles. And this case was also referred to by CCS in many circumstances, in many landmark cases regarding cartels, and one of those is the express bus operator case. And before we move on, in terms of the meaning of agreement to be falling within the scope of Section 34, the agreement in this aspect has quite a wide meaning according to the Section 34 guidelines, and it includes both legally enforceable and non-enforceable agreements, and those agreements can be written or oral. All that is required is that parties arrive at a consensus on the actions each party will or will not take. This concept looks fairly simple, but my observation is that in practice, it might be quite difficult for CCS or the competition authorities to produce enough evidence to establish the consensus, since the nature of these meetings or communications are rather discrete. But one factor that allows CCS in this case to successfully establish the consensus is the parties' cooperation in providing the meeting minutes and explanations to each conduct of them. And the reason why they are very willing to provide CCS with the evidence is the leniency program, which I will mention at the end regarding the penalties. But just to give ahead of warning. So, and now we are moving on to the second issue, is whether each undertaking, the parties in this case, participated in an agreement or a concerted practice. And in the decision, CCS mentioned a plethora of precedented case, both from the UK and the EU case. And basically the concept is that for a party to be considered as having participation in the agreement or concerted practice, which is a violation of Section 34, we can see that it has quite a low threshold for an undertaking to be considered as a participant. So the standard is that if an undertaking participates in the meeting in which the anti-competitive agreements are concluded, and if that undertaking did not manifestly oppose those agreements, that already established participation, and this is according to the US Fallon case, the first case. And next, the CCS also mentioned that even if an undertaking, a party, did not follow through with the agreement made, that is not sufficient to prove that it is not a participant in the anti-competitive agreement. So this is quite a low threshold. So if you're in the meeting, even if you didn't follow through with what you agree upon, you'll still be considering to have been participating in the anti-competitive agreement under Section 34. And the last case that CCS mentioned is the AC Trohan, AG, and Commission. So even if the party did not take part or participated in the whole cartel scheme, or even if it has a minor role in the scheme, it is not a justification for that undertaking to be considered not a participant in the infringement. So we can see from these three cases that, as I already said, it is quite a low threshold. So it is best for a company not to attend those meetings in the first place and not having any communications. But if by accident it participated in those meetings, one thing it can do to render itself out from that situation of being in risk of being in violation of Section 34 is to try to distance themselves from those actions as much as they could. I mean, maybe by means of having an express denial of agreeing to those agreements, or maybe have a publicly distance from those undertaking in the agreement. And now, in moving on to the third issue, which is quite important as well, is whether the agreement made between the undertakings in this case have an object or effect of preventing, restricting, or distorting competition within Singapore. And in this issue, we can separate it into two categories. First category is whether the agreement has an objective of restricting competition. And the second is whether the agreement has an effect of restricting competition. So CCS made quite clear to separate between the object and the effect of the agreement. And One interesting point that CCS made in a decision is that if the objective of those agreements is already sufficient to establish that it has the objective of restricting competition, it is not necessary to consider whether the agreement has a adverse effect on competition. So if you satisfy the objective requirement, you do not have to consider whether the agreements actually have an anti-competitive effect. So again, it is quite a low threshold to hold an undertaking in violation of Section 34. And in this regard, CCS, this view of CCS is actually in line with a number of ECJ case, the case in the European Union, which consider that, well, if you satisfy the objective requirement, you do not have to consider whether it has the anti-competitive effect. And now we are moving on to the decision by the CCS. So after we consider all those issues that I've already mentioned, CCS finds that the parties have actually infringed the Section 34 of the Competition Act and directs each of the parties to pay financial penalties. And before we move on to the amount of the penalties the parties were ordered to pay, the CCS has also mentioned how they come to reach the amount of penalties, and that is according to, again, the CCS guidelines on the appropriate amount of penalties 2016, or the penalty guidelines. So there's a lot of guidelines by the CCS in this case. And in the penalty guidelines, they have a 6-step approach in calculating a financial penalty. The first step is that they will calculate the base penalty, considering the seriousness of the violation and the relevant turnover of each party. And then after that, they will adjust the penalty, the base penalty, according to the duration of infringement. So you take the base penalty and then you multiply it by the duration of the infringement, but that will not exceed 3 years. And then the step 3, you will either get your penalty increase or decrease according to the aggravating or mitigating factors. So the mitigating factors can be like if after the infringement, the company has issued a code of conduct or have reviewed its policy regarding meetings with other company, then that can be a mitigating factors in decreasing the financial penalty. And then step 4, there will be other relevant factors that CCS will consider as well, and to impose, but these relevant factors will be in order to impose an uplift on the penalty, so not to decrease the penalties. And then moving on to step 6, if the penalties after step 4 is higher than the maximum penalty in Section 69(4) of the Competition Act, then there will be some adjustment that need to be made. And then the final step is that there will be an adjustment if the undertaking can satisfy the requirements for immunity, leniency reductions, and or the fast track procedure discounts. So that is a lot of stuff that CCS need to go through, and in its decision, CCS go through this 6 step with all the 5 undertakings which are under investigations. And then finally, the amount of penalties. I specifically mentioned this step 6, which is the adjustment for immunity, leniency reductions, and or fast track procedure discounts. In this case, Panasonic received a total immunity from financial penalties, even if it was found to be in violation of the Section 34 as well, but it was immune from receiving the penalties because Panasonic was the first party to come out to CCS and give the information on the agreements between the party. So I think the other four parties must be quite not very happy with Panasonic's action, but well, Panasonic was granted immunity anyways. And then after Panasonic, Elna, Rubicon, and SCC come out with a under CCS leniency program as well. So these three companies also receive a discount in their penalties, but the amount of discount was not disclosed by CCS. But in the considerations for how much a discount a party will receive will be considered on the stage at which each party came forward. If you came forward very early, you may receive a higher discount. Also, the evidence already in CCS possession. So if you came out when CCS doesn't have very much evidence on its hand, that might be another factor which will help you getting more discount as well. And final consideration is the quality of information you provided to CCS. If the information provided is very helpful in helping CCS determining whether you violated Section 34 or not, then that will come into account when considering the discount as well. One party that did not receive that did not come out for a leniency program under this case is Nishikon, but Nishikon argued to receive an adjustment of the penalties on grounds of mitigating factors that I've already mentioned, which is under step 3 of the penalty guidelines. So the mitigating factors that Nishikon raised in this case is that it has in place a competition compliance measures during the period of infringement. But however, although a compliance program can be considered as a mitigating factors, but given the seriousness of the infringement and Nishikon involvement in the violation from the beginning to the end, CCS regarded the compliance program as ineffective and did not granted Nishikon a further reduction of the penalties. And since Nishikon did not apply for a leniency program, it did not it did not receive any further discount, and in fact it paid the most penalty amongst the parties in this case. So that will conclude our presentation. Thank you.
Thank you. Great job. Wow, very interesting, right? Okay, so any points, questions on the article?
I think it's a really interesting case, and like especially the leniency program. I think that's a very effective way to like encourage collaboration between like the authorities and the respondents.
Yeah, I agree, because like if there wasn't the leniency program, CCS wouldn't have gathered this much of evidence to impose the penalties on these parties.
Mm-hmm.
Because most evidence were gathered from the meeting minutes and the explanations provided by each party, which is quite a detailed explanation because they want to collaborate as much as possible to reduce the penalties imposed on them.
Yes.
Yeah, so it's like a win-win for both sides, and I think it's it's just really interesting.
Yeah, I mean.
Also, the object versus effect determination. I'm not sure if it's like a good idea to have such low threshold for competition law, because if I understand correctly, they're just looking at the intention of the respondents, right? They don't really care if the acts of the respondents actually had effect on the market, which I don't know, personally, I feel like they should focus more on the effects rather than just like the mere intention. I don't know. Yeah, this
Yeah,
is my.
what do you think? What do you think, Bella? Or what do you think, Sanawat or Kishwit? What do you think about these 2 points? Especially the second point, on the low threshold.
Well, I mean, yes, I agree with Prima's point that it shouldn't have such a low threshold.
Mm-hmm.
But they focuses more on the objective meaning and the proposed purpose of the agreement, not only the intention of the parties. So in determining the objective of restricting competition, it doesn't all. There's many factors that can come into account when considering the objective. So I think since there's so many factors that CCS can take into account, that is why it doesn't focus much on the effect on the competition. I think in this case, CCS has quite like a handful of evidence to already convicted these parties. So I think they didn't focus much on the effect on the competition.
Mm. Mm. Okay. What about you two? Kishwit or Sanawat, do you have any point or any comments?
I think the practice in this case is it involves the price fixing agreement, and I think the CCS like the CCS thought that this kind of actions will have the like effect to the competition anyway. In the guideline on section 34, they state that even if you are the SME even if you are the SME's business, if you do this price fixing agreement, they will just ignore the threshold level and just they will only consider on the effect of from the price fixing agreement. Like it will always have the I can't put a word for this.
I mean, you mean that price fixing is already obvious in itself that it has a anti-competitive effect?
Thank you so much.
Okay.
Yeah. I mean, so let's start. Let's start with these 2 points. I think especially the latter point. Let's start with the latter on this threshold. Well, I know that this thing is quite bizarre. Especially it's just one of those per se, one of those conducts that are governed by the per se rule, right? Which basically means that it doesn't matter what your intention behind is. Whenever the conduct has been found, you would be found guilty, right? This is the illegal per se principle that is being adopted in this particular conduct of cartel, and particularly on the hardcore one as well. So if I have to argue your sort of, I mean, I do agree that eventually you should really care about the consequence on the economy. If there's no consequence, then there shouldn't be sort of any punishment or any measures against it. But if you imagine in the business world or in reality, if I agreed with my business competitors upon some certain things, for example, to fix the price or to limit the supply, right? But suppose something something comes up afterwards, and it basically makes my intentions basically go in wind, right? It just doesn't materialize because of some external factors. And we know that in the economy, there are so many external factors that could affect the consequence of your business decisions. Right? There might be some shift in demand. There might be some new competitors entering into the market because seeing your price is high, and then the cartel might not be sustainable. So there's so many other factors that would say that, not really say, but that would come along the way between the dates that you agreed upon something and the date that your agreement is materialized, right? So and that is not something with good intention at all. It's just some uncontrollable factors. What if you make an agreement and something comes up afterwards, and basically you can't follow your agreement? Would you treat that as something that has never happened? Or would you treat that you have actually you had a bad intention already, but just that there was no consequence because of some external factors, right? So I mean that is probably the counter argument to the point that we have a low. What meant by low threshold is basically saying that we focus on the conduct, but we don't care much about the consequence because there's so many things that would determine the consequence. What do you think? What if I argue this way? You think it makes sense or not?
So you mean that you're the alleged party and then you want to argue with CCS?
Oh, not yet. What I meant is just like the fundamental concept of this cartel, right? Because I mean, if you look in the previous slides, you talk about, especially is the third issue, right? That you care about the object, right? What you agreed upon, and once the agreement has been made, or even that the threshold is even lower, right? You can say that even if you were there in the meeting, and you may decide afterwards that I don't want to follow what I agreed, right? Then you consider that basically the conduct has been done already, and you will be held liable. So so in this case, in the old days, actually this is a very hot debating issue in the field now, because in the old days you need this sort of stringence, because mainly because the conduct is really difficult to detect, right? The conduct is really difficult to detect, and what you aim to do is you try to deter these business operators from entering into the agreement at the very beginning. And that is why you need to set the threshold to be so low, to the level that they dare not to try, right? And when we include the another piece of argument saying that because there are so many uncontrollable factors between the date or the point that you make an agreement and the consequences that would happen in the market. What do you think? Do you think it makes sense now to have a low threshold, or you still think it doesn't make sense?
Well, personally, I still think that it makes sense because, like, I mean, if you look at to the objective of having such a low threshold, because you want to prevent them from actually thinking of forming a cartel in the first place.
Mm-hmm.
But yes, from the people who are under the law side might be it might be quite difficult for them to, I mean, operate as business, because some meetings can be like a very normal meetings, but I don't know, there may be so many things that can go wrong.
Mm. What about the others? What do you have any idea? I think one interesting point is this is one of the conducts that has been criminalized, right? It has been criminalized, and when you consider the case, some criminal principles must be used as well. And one thing is about this burden of proof, right? And the usually if you don't have any good evidence, you should give the benefit of the doubt. And that actually leads to the first point that you raised, which was the leniency program. Okay, first question: do we have it in Thailand?
I've already searched, but I have not found any leniency program. But I'm not sure if I'm correct.
But that's like a similar program. I mean, like similar concept in criminal procedures, right? Like if you give some kind of useful evidence to the authorities, then there's a chance that the punishment you may receive will be reduced. But I'm not sure if this principle applies to competition law.
Mm-hmm. Mm-hmm. Yeah,
actually, sorry.
Sorry, please go ahead.
So you mentioned the burden of proof, and in the CCS decision, it mentioned that the standard of burden of proof it used in this case is the civil standard. So it does not have to be like beyond reasonable doubt. It used like the proof on the balance of probabilities instead.
Yeah. So yes.
I have a question. Like, is it normal to like people in an essential role in the company, like from in this case, will you say it's normal for them to like go into the meeting together, like if they are like CEO and they went into the meeting together, but they are also the competitor in the same business? Is it the normal practice?
Yes, it is. But it is natural, right, that you would find people in the same industry at the same event. Well, there are so many business showcases, business events, or networking events where you will find competitors at the same place. That is so normal. So I don't think just just the fact that you are happening to be at the same place at the same time would be sufficient. But there must be some sort of like hard evidence saying that you did talk about this sort of concerted practices, right? So yeah. So yeah, to address your point, it's super normal, and one should not restrain from attending business events just because they are afraid of having this risk. Right? Is that the point that you were trying to point out?
Yes.
Okay, come back to this burden of proof because Prewa said that the threshold was quite low as well, right? Even when it comes to this burden of proof. Why? Why do you think it is the case?
Well, I think it's interesting when you said that, like, if you set the, like, if the threshold for liability is set at so low, businesses won't even try, like, to think of those agreements in the beginning, because, like, in a way, I think setting the, let's say if we set the threshold higher instead of lower, then there's a tendency that there are legal loopholes in the system, and that, you know, businesses might try to find lawyers or people who, like, would come up with contracts or agreements in a way that could escape these legal loopholes and still enable them to do those acts. But, like, setting the threshold low means that there's a high probability that those agreements won't even work to begin with, because the fact that there is an agreement in the beginning is already sufficient to call for liability.
Yeah, because if you think about it, especially the content within the agreement, we're not talking about the implementation after the agreement, right? It's sort of like, let's say we talk today, and there are just like, I don't know, vast amounts of possibilities. I mean, was pool of words that we can choose to use, right? I can say, I can put it in one way, and basically you can understand that we can increase the price in the next quarter, or say in the next period. And if you, and surely in the court or in the procedure, you would need to provide this sort of like rights for the defendant to defend themselves, right? So the accused party could say that, oh, I'm talking this way just to complain, right? To complain that, well, you know what, our costs are all really high, and I think it would be a good idea that we can increase the price a bit. You look at that industry. For example, you're selling, in this case, it's a capacitor, right? And you look at the what the graphite industry, for example, the other, and you said like, yeah, you look at them, and they increase the price like quite substantially. I think that would be a good idea in our industry as well, right? So first, this is our conversation. Would you consider this an agreement? Well, my intention could be that this is already an agreement, right? Because I give the signal to you that, okay, let's increase the price. But if you're representing me, what would you say? You would say this is just a mere complaint. I'm just complaining about the business, about the difficulty, and this is not considered as the agreement. And that is why when you talk about possibility, it doesn't mean that when it's 50-50, you say that this is absolutely an agreement. But you could probably have a lower threshold, because what you're talking about is like the base evidence that you could find. I mean, if you can find like the price table and sort of a clear agreement to instruct all the participants, then that is good, right? But that is probably too ideal. And I mean, you ask yourself, if you are business operators, would you do that? Would you put it that way? No, right? You would try to sort of disguise it a bit and put it in a way that, and also there are so many other channels of language, right? You can have this body language, you can have all these tones and different things, right? So our modes of communication are not just not singletoned, in the sense that we don't really just use words to represent meanings, but also we have all kinds of communication tools as well. So that is why you sort of overcompensate that by setting the threshold to be a bit lower. For example, if you say that beyond doubt may for example, 90%. But that is a typical case. We cannot, I mean, realistically, we cannot achieve 100% certainty, right? Whatever the cases, or whatever the incidences. But let's say that 90% is considered as the right threshold probability to say that this is beyond doubt. But in this case, because there are so many uncertainties and so many, well, loss of message, so maybe you sort of overcompensate that because you know that the other side, the lawyers representing the other side would push that threshold anyway, right? So that's just possible as well. And that is why there's really focus on this. And because we touched this, right? Because we touched this part that cartels are really difficult to be detected. The best thing we can do is to deter. And when you set these, I mean, all lower thresholds, what you should have in mind is you don't want to detect any cartels. You want to set it to the level that people just decide not to enter into the agreement at the very beginning, right? So there are two kinds of effects, right? The detection effect, which is good. I mean, if the cartel has been formed and you can detect it, you can punish it, and you give a signal to the society that, you know what, if you enter into this agreement and we can detect the agreement, you will be punished. It's supposed to be okay with the idea that, okay, because there are so many controllable factors, and maybe the effect of your agreement is not materialized. That's okay, right? But another kind of effect, which is even more desirable, is the deterrence effect. We just want to deter and say that giving this really low threshold and very harsh punishment. And that is actually the whole reason why we criminalize cartels. Because we want to make it as severe as possible. And one reason is because we know that it's really difficult to detect. So we want to make a punishment to be as harsh as possible in order to deter business operators from entering into the agreement from the very beginning. And that actually leads to the creation of leniency program, right? You create a leniency program not to incentivize people to come forward and provide information, because there's no guarantee. And you imagine business operator, you are not, I mean, you're not doing business on one go and then you just set apart and do your own things, right? There must be some sort of like collaboration, some sort of good collaboration as well. Some sort of relationship in the long run, especially in the Eastern culture, where this business relationship is really important. So if you are a business operator running your business and you know that your competitors would be your frenemy, right? Basically, there's this term like being a frenemy, in the sense that you might need to rely on each other in certain way, but at the same time you're competing against each other in another dimension as well. The thing is it's really difficult already in order for you to come forward and provide this information to the authority, because that would demolish your relationship, right? So even if you have this leniency program, it's still very difficult for firms to come forward. They would come forward just because they feel that it is worth doing. And if you take into account the future relationship or the long-term relationship, then you need to provide them, well, golden carrot, right? Golden carrot to seduce them to come forward, because that stake is quite big, right? Because there are so many consequences that may happen by basically betray your competitors. All right. One last point I think is interesting as well is, you know that leniency program has more than one variations. Okay. In the US, it is allowed, the leniency is allowed, or the amnesty is issued to just the first player who come forward, and the subsequent, or the second or the runner-ups would not get any amnesty at all. So it's 100%. It's all or none. But in Europe, and I think also in Singapore, they provide it to more, right? But in the sort of like this, well, how to put it, decreasing rate, in the sense that you give 100% to the first, maybe you give just 50% reduction to the second, and 30% to the third to come forward. The question is, why do we need these two different systems?
I mean, for the Europe and Singapore system, I mean, I think they focus on encouraging firms to come forward as much as possible, because sometimes the first firm to come forward doesn't mean that they will give the best quality of evidence, and maybe they need more in order to establish the liability.
Okay.
So that is why they use the discounted system.
Yeah, a good point. Good point. So it means that when you design this system, there are two kinds of things that you need to trade off, right? The amount of information and the incentive to come forward. Because if you give it just to the first for 100% and none to the runner-ups, basically you maximize the incentive, right? Because you don't have to wait for another to blow the whistle, right? I mean, it is always for your base benefit to come forward as soon as possible, because if you are too late or too slow, then other people will just come forward and you will lose the opportunity. So that is maximized. That is like you put so much weight on this incentive. But on the other hand, in Europe, in Europe or Singapore and or other jurisdictions, they try to include as many undertakings as possible because of your reason, right? Because they want to have more and more information. So it depends on the assumption as well. If you believe that most parties should, well, essentially have the same set of information because of the nature is an agreement, right? When you enter into this agreement, it should be to some extent symmetric, right? You should have what the other parties have. You should know what the other parties know. And if you think that is the sensible, it's like sort of sensible presumption, then maybe maximizing incentive is a good idea. But if you think that there is a level of asymmetry of information processed by different parties, then you might pick the European system, in which you don't just provide to the first comer, but also to the late comers as well. Right? I think that there are some other points, but I wanna listen to the second group as well. So and then we can mix the issues. Yes, please. The second one.
One second, sharing the screen, but I'm not sure if it works. Can you guys see?
Yeah, I can see it.
Okay. Great. So, Pina, you ready?
Yeah.
Okay. So hello everyone. Today we'll be talking about the case called the International Graphite Electrode Cartel, decided by the Korean Fair Trade Commission, or the KFTC. So before we go into details, let me explain to you what a graphite electrode, which we'll be talking about, is. As you can see in the picture, it is a heating element used in an electrical arc furnace, which is a steel making process where, wait, there's something wrong with the slide. Where scraps from old cars or appliances is melted to produce new steel. So basically, it's a really important material used in the steel industry. I think there's something wrong with my laptop. Okay, so I'll be discussing the backgrounds of the case as well as the related principles concerning application of Korean competition law, and Ben will go into the details of like how those applications work. So as for the background of the case, this case concerned 6 manufacturers of graphite electrode from the US, Germany, and Japan. There was one company from the US, one company from Germany, and 4 companies from Japan. All these 6 manufacturers, or all these 6 companies, are the respondents in our case, and they met at a hotel in London in 1992 to discuss cartel issues and establish what is referred to as the London Principle. But this will be explained by Bin. We were unable to find like a clear English translation of the analysis of market definition. But we were able to find information that like concerning the market dominance. We were able to find evidence that the respondents held over 80% of the supply of the graphite electrodes in 50 regions around the world, and this established its market dominance. As you can see in the pie chart to the right here, all the like red and pink colored pie sections are the entities involved in our case. The UCAR International, which is the US company, held over 31% of the market share. The SGL Carbon Aktiengesellschaft held 25%, and the rest of the 24% were held by Japanese companies. This means that like 80% of the supply of the graphite electrodes are supplied by members of the cartel, and only 20% of the global supply were of non-cartel members. Now, what is interesting in our case is that, as you can see, this case is decided by the Korean FTC, but neither of these companies were based in Korea or conducted any actions in Korea, because they were discussing in London, and like all of them were companies based in US, Germany, and Japan. The only linkage that like South Korea really had with these 6 respondents were the fact that like South Korea did not have any domestic graphite electrode manufacturers, so it depended solely on imports, and 90% of South Korea's imports are supplied by members of this international cartel. So this is why we believe that this case is worthy of discussion, because it concerns the application of Korean competition law on foreign businesses, or to be particular, like the application of Korean competition law on international cartels conducted by foreign businesses. It was also like one of the very first steps conducted by the Korean FTC to proactively protect domestic consumers against the anti-competitive practices of overseas businesses. I think this is also influenced by the global and like market trend during the time, because in the late 1990s, it was the time when a lot of overseas businesses started having investments in Korea, or started like there was a rise in multinational companies and like international corporations basically, and a lot of these business trend has caused abuse of market dominant power or acts that would cause damage to domestic markets. So in a way, it was like an effort to push for a protectionist policy by the Korean FTC, and this was also evidenced by like many scholars, as well as like reports. For example, in March 1998, there was a report concerning measures against abuse of dominant market behavior by multinational businesses, and in the annual the Korea-U.S. Competition Policy Consultation meeting in Washington, D.C., the KFTC was also pretty explicit that it intended to apply Korean competition law to foreign firms that have impacts on Korean markets. So this raises a really interesting question of how competition law, or if competition law can be applied extraterritorially. And to answer this question, I would like to introduce the effects doctrine. And the effects doctrine basically says that the court shall exercise jurisdiction by applying competition law of a country to acts engaged outside of jurisdiction of the country if the anti-competitive acts conducted overseas affect the fairness and freedom of domestic markets. This is like a general definition of what the effects principle is, and South Korea has a similar adaptation of the effects doctrine in its Monopoly Regulation and Fair Trade Act, or the MRFTA, which is in Article 2.2, and it says that in cases where any act that performs even abroad affects the domestic market, then this act, or the MRFTA, should apply to such act. And I think there are two main opinions on whether or not competition law can be applied extraterritorially. On the first side, like, people would focus on the effects doctrine, like how South Korea did in our case. This is also evidenced by the US and the European community. Both the US and the European community believe in effects doctrine because they believe that the FTC should be able to hold, or the courts should be able to exercise jurisdiction over acts engaged outside of the country's territorial jurisdiction if those acts affect domestic markets, and in order to like expand the level of protection towards businesses and domestic competitors. On the other hand, Japan was really hesitant to apply this doctrine of effects or hesitant in applying competition law extraterritorially. And the Korean FTC shared a similar view with the Japanese FTC in the beginning. They decided that acts should be limited only to it, like the application of competition law should only be limited to acts that were done within its jurisdiction, or at least like they would only accuse foreign companies if foreign companies has subsidiaries or branch offices in Japan. So Japan and South Korea in the beginning basically had a threshold of extraterritorial competition pretty high, and they did not believe in effects doctrine. But as you can see, Korea has shifted its view towards the late 1990s from being the more traditional like Japan to the more liberal and setting the threshold lower like the US and the EC. And this is what is happening in the graphite electrode case.
Okay, thank you, Ms. Prima. For now, I will go and explain in further details of the agreement made by the 6 graphite electrode manufacturers. The main clause for this case in this agreement is called London Principle. And according to this clause, the parties agreed to respect each other home market by matching any price increase made by a cartel member located in that country. And what can be implied from this clause is that if uh, if the party in their home market increase their price, another party that is in that increase the price at the same level to match it, right? So it affects is would be like there will be less competition between the parties, and also in contrary, if we can imply in another direction, if the country in that their home market decided to decrease the price in order to eliminate the newcomer in the market, another party will also decrease its price, right? So that it kind of like dumping, so that and the new entrant to the market could not survive in the market anymore. And also, the members also agree to in a non-home market, which is a country where no cartel participants are present, the cartel established a detailed agreement on the sales price, which in this clause, it is quite obvious that is price fixing, right? And also a South Korea is included in this category. There are another clause, for example, a no rebate, no discount clause for which used on like country mainly in Asia, and the party also agreed to charge an extra premium for a large size graphite electrode. And another clause they agreed is that they will limit the transfer of a technology for the graphite electrode, and not only the technology, but also restrict the licensing of graphite electrode manufacturing technologies, so that there will be newcomers into the market. And lastly, they have an intention to conceal their activities by nickname in the meeting and also in the contract. For the next part, the next slide, please. Thank you. In this case, the KFTC, which is South Korea Authority, start the investigation based on the case that already been investigated and penalized by US, Canadian, and Japanese competition authority. So the KFTC used the evidence that already exists, which is an agreement that I already mentioned before. And another point that KFTC has to prove is that the agreements have a damage on a Korean market. And as a result of the finding, KFTC able to reveal that Korean market suffered a direct financial damage as a result of cartel sales in Korean market, according to their collectively determined price. And there are also, which is a source of price of the global market of graphite electrode more than 50% during 1992 to 1997. So KFTC issue a corrective order and impose a surcharge to this sixth company. And after the decision was made, 5 of them, which include UCI International, SGL Carbon, SEC Corporation, Tokai Carbon, and Nippon Carbon, appeal to the KFTC directly, so that KFTC maybe dismiss the decision or reduce the surcharge. However, the Showa Denko filed a lawsuit directly to the Seoul High Court. And as a result of appealing to KFTC, the Nippon Carbon surcharge was reduced. However, all another appeals was dismissed. And according to UCR International cooperation to KFTC, UCR International surcharge was also reduced. Therefore, UCR International and Nippon Carbon quit their appeal because they are right now they are satisfied with the discount. I will give you a briefly details of this is a leniency program of a KFTC. In this right, the leniency program in South Korea is that if the first one come to confess before the investigation start, that one will be the charge on that company will be like exempt 100%, and the second one who come will give a 50% discount. However, in this case, the investigation already started, right? So the first one to come forward with is UCR International receive a 50% discount. Sorry, is a previous slide.
Which one?
Yeah, it's still in the slides. And as right now, there are 4 companies that file a lawsuit to the Seoul High Court, right? In the Seoul High Court, the Seoul High Court held that the MRFTA is applied made overseas by foreign companies by incorporating the doctrine of effect and the place of implementation theory to the surcharge of Showa Denko, which as Showa Denko is the only company that didn't go to appeals and didn't attend the meeting. So the charge was substantially more than another one. So what Seoul High Court held is that even all 4 of them has was charged, is the law is applicable. The surcharge on Showa Denko will, therefore, the 4 of them still did not satisfy with the judgment and appeals to the Supreme Court. Also, KFTC appealed to the Supreme Court as well, according to the reduction on the surcharge. And let's move to the next slide. Prima, please, the next slide, please.
Isn't it this slide?
No, it's the next slide. Yeah, thank you. And this is the judgment of the Korean Supreme Court on 2004. The court held that for the Fair Trade Act is to promote fair and free competition to encourage thereby creative entrepreneurial activities to consumer and to facilitate balanced development of the national economy by regulating unfair collaborate act of business entity according to Article 1, and the entity who is the subject of unfair collaborative act is defined as a person who conduct a manufacturer, business, service, or other business not limited to domestic business entity according to the Article 1 and Article 2 of MRFTA. Therefore, the Supreme Court upheld the Seoul High Court decision that those companies who made an agreement on the sales of graphite electrode, MRFTA should be applied to the extent of that agreement, which affect the Korean market. And according to this decision, there are mainly three elements that the Supreme Court justified from Seoul High Court decision, which is first, the existence of an agreement that facilitates illegal acts, and second, the intention to target Korean market, and third, the effects on the Korean market. And after the Supreme Court made their judgment, this also lead to the revision of Article 2.2 in 2004, which Ms. Prima already mentioned, right? So it's allowed for the extraterritorial application of MRFTA based on the effect doctrine. And this concludes my presentation.
Thank you. Any points?
When we attach like the unfair the KRFTA, in case you are interested.
It wasn't in the version that you uploaded, right?
Yeah, we just recently made like final edits last night. So, but I'll upload like the more updated version like after the class.
Thank you. Any? Well, there's so many interesting points. But any points you wanna kick off discussing?
Well, it's probably the extraterritorial application.
Yeah. What do you think?
It's quite similar to our case, the Singapore case, because it involved like firms from other jurisdictions as well.
Yeah.
And also it involved like an agreement made outside of Singapore, outside of the country as well.
Mm-hmm. But I believe in your case, there was, one party is a Singaporean business operator, right? But in this case,
Yeah.
completely none of the business operators is not Singaporean, is Korean. But again, extraterritoriality is extremely interesting. Do we have it in Thailand? This Competition Act. Would you say that we apply extraterritorially as well, or we just, the Competition Act just applies domestically?
I believe we don't have like a provision that is similar to the Article 2.2 of South Korea.
No, we don't. But we don't have an article saying that we are regulating domestic business operator only either.
So it all depends on the interpretation of the OTCC.
What do you think? But it is a bit unfortunate, but there was an incident, right? The Grab merger, but that happened before the sub-regulation on merger was issued. But what do you think? Do you think we can? The Office of Trade Competition Commission could basically exercise that power beyond the territory, or is still? What do you think?
Well, if they use the effect doctrine, I think they can, as long as like the actions has an effect upon the competition in Thailand.
Mm-hmm. Yeah, because if you look at the provisions of the Competition Act, basically it says that business operators do something, right? They do something, and well, in Cartel is basically they didn't put explicitly what the consequences are, but of the nature of the agreement. But if you look at other provisions, especially on these well, abuse of dominance or merger. It's basically saying about well, about competition, right? Or especially if you look about unfair trade practices. And one section that I want to point out is the section 56. Sorry, 58. What do you think?
I think this concerns personal jurisdiction. It's not really affects doctrine, but more on how Thai or like Thai entities should not basically be part of a cartel in a foreign country, right? Like
So
section 58.
you think sections 58, section 58 is applicable to the previous case that we discussed? You think it is?
The Singapore case?
Yeah, the Singapore case.
Only to the Singaporean entity then.
No, I
But
mean,
not
suppose that the same thing happened in Thailand. Like Thai business operator enters into this cartel with other entities. You think we can use this case?
I'm not sure if it says no business operator, but does this is the definition of business operator here limited to only company registered under Thai law, or like any and all business operator in the entire world?
But this is a problem, right? I mean,
Yeah,
if you look at
it's
some
really
other
vague.
acts, this is
Maybe
quite clear, right? Normally you would find a section saying that what is the scope of jurisdiction of that particular
Yeah.
act, right? Within the Kingdom of Thailand, or if you would expand it, maybe you expand it even further. But there's none of such a provision here in the Competition Act. So
But
what do
I
you think?
think I'm not sure if this doctrine is applicable, but like in laws concerning, say, like cyber activities or technology, like social media platforms and stuff, there's also the application of the effects doctrine in those contexts. But another doctrine that is also used in, like, say, cyber law, or like uh, incitement of certain acts, for example, hate speech on the internet, there's something called the sliding scale doctrine, which takes into account like the consumer target. So like if we were to apply that to our case, like of South Korea, the six manufacturers, like, they passed the effects doctrine threshold of conducting acts that had an effect on Korea's domestic markets. And at the same time, because South Korea was so heavily reliant on the supply of products from this cartel, like 90% of its imports, like they had no domestic production of the graphite, and all 90% of its imports are from members of the cartel. We can probably establish that like this cartel has Korea as one of the big consumer targets, and according to like the sliding scale doctrine, there is like a linkage for liability, because the actions of these cartel members affected South Korea, and yeah, like there's like a base, like a consumer target.
Mhm.
So so if like both of those doctrines are applicable, say in Thailand as well, then I think like section 58 scope of liability would not be too broad in a way that it's like outrageous, because it would have to take into consideration whether or not Thai consumers are affected by the acts carried out by business operators that the OTCC intends to hold liable for. Because I don't know, if I feel like if it can be any business operator at all in the world, then OTCC will sort of be in the position of a global police or something, and it's just, I don't know, I don't think that makes any legal sense.
Yeah.
And like, I don't think other countries has accepted like the jurisdiction of Thai court or like Thai OTCC either. So I don't see why, like, say if they were to file a complaint against a company with absolutely no linkage with Thailand, like, I don't know how that complaint would take any effect on them.
Yeah, good point. But yeah, I mean, the point that you were I presume trying to make is there must be some sort of tangential contact between this sort of conduct or business operators with our jurisdiction. And
Domestic
I think one good example of this jurisdiction idea is, for example, PDPA, right? You look at PDPA, and they do have three scenarios. One is quite clear. That's what they call data controller and data processor that are operating in Thailand. That's it. But also the case that they have subsidiaries in Thailand. And the third case is what you said, right? Even if they have no relationship whatsoever with any business operator, juristic person in Thailand, but they are offering service or product to people who are situated in Thailand, or monitoring the behaviors of people, regardless of their nationality, but within the Thailand soil. So, but again, what if I say that if you look at section 58 and if you interpret it in the other way, would it mean that, because it say that, okay, as a business operator, you are prohibited from entering into the contract or carry out a legal act with a business operator in a foreign country. Could it imply that the business operator that we're talking about in this act means domestic, being the business operator in the domestic country, in Thailand? Do you think we can interpret it that way? Because if that is the case, then basically we don't have any extraterritoriality. Did I say that?
You mean the section 58 is applied to a Thai company situated in Thailand and a foreign company coming into Thailand to conduct business? Is that your question?
No, my point is, because if you look at the section of the provision itself, it say that no business operator shall carry out a legal act or enter contract with a business operator in a foreign country, right? Could I say that it implies that whatever we mean by business operator, it means that it is not a business operator in a foreign country?
The provision says business operators in a foreign country.
No, but you look at it. You look at the section 58, right? It says that the business operator, suppose that you carry out a legal act, right, or enter a contract with a business operator in a foreign country.
You mean the act does not have to be committed outside of Thailand, but the business operator has to be foreign?
I have a question.
Yes.
Like in the last part of section 58, it states that as a whole. I'm not sure how whole is it. I mean, is it only in Thailand, or is like you you need to like look into the business? And I mean, if it happen to have the Thai company take part in the foreign party, and then the whole business was just like not just in Thailand, right?
Yeah, I mean, how whole is that? A good question. But I mean, to my understanding,
It's only in Thailand, right?
it's not really whole, but it's like in general. I think. I mean, honestly, I think that the translation is a bit problematic. And if you look at the Thai version of the Competition Act, this is quite clear. The question that I was asking is so clear that they say that the domestic business operator and foreign business operator. They do not say just like business operator and foreign business operator. They say domestic business operator and foreign business operator. If you look at the Thai version, right? So again, it's still inconclusive. What do you think? Okay. Suppose that there's nothing written explicitly in the law, and this is something implicit. What I mean, do you think we can? The next question is, okay, it is now up to the commission, right? Whether they will make a decision whether they would expand the territory to basically the whole world, and whenever the effect is substantial enough in Thailand, then there would be, well, basically they were involved in these conducts and enforce the law on these foreign businesses as well. Could they simply do that? I mean, we set aside a possibility, but could they simply do that with a given law?
I mean, they probably can, like, apply their jurisdiction extraterritorially if they want to. But how feasible is that? I'm not sure.
Mm-hmm. I think you mentioned about the tools, right? The tools which you may use, like this international committee, right? Like have this positive committee, and you could do it bilaterally or multilaterally. But would it work?
I think like the Thai translation, like the Thai version of the act, made it really clear that the act will be only applied to ผู้ประกอบธุรกิจในประเทศ so it's not like they can apply this act to anyone at all.
Well,
but it has to be like entity operating businesses in Thailand, like business operators in Thailand.
Yeah, I get your point, but that is in section 58, right?
Mm-hmm.
The question is, if ผู้ประกอบธุรกิจ or business operator means only domestic business operator, why do they have to put it explicitly in section 58 that this is domestic business operator who can't do this, right? I mean, I hate playing with words, but You understand what I meant, right?
Wow, that's a really interesting point. I don't know.
I think the Thailand Competition Act is like try to stop Thai business operator to take part in like international cartel, and they will only like punish Thailand business operator. But I think in the foreigner business operator, they will be punished by their own law. Oh, I'm sorry. I I I I lost the word to put again.
So you think that there will be the same? Okay, Shimit, you want to say something?
In my opinion, right, and in the article 58, I think it's like intend to have a effect only on the Thai business entity. For I mean effect. I mean like if the cartel is made, Thai entity will be the only person who will be responsible for this cartel under the Thai law, right? So it's like I think it's have an effect on Thai because for it's like even though there are 10 of them, if you are Thai and you join them, you will be responsible for such an action. Like it's it's I think it's like make Thai company doesn't want to join like in that like in that cartels.
Okay. Yeah, I mean that is what Section 58 says, right?
Mm-hmm. And I think it's like it's meaning like more like a what can I say? It's make Thai feel like uncomfortable, like unfair compared to another international company that join in this cartel. Like that's what I mean.
Okay. All right. Okay. So good to know what say that we well basically this is for just domestic business operator, right? I could usually say that this is just basically unfair. But I think what was trying to point out that there must be pretty much the same provision elsewhere as well. And each country takes care of its own business operator, which is true. I mean, we have exactly the same, not we have, but Indonesian competition law actually has the exact same provision saying the same thing in that competition law as well. So if you believe that each country would take care of its own business operator, then that's okay, right? When they enter into this international cartel and you have this provision, and basically for the business operator within each country, then it will be taken care of by its own its own competition law. But again, I still think that this is not the limitation to the extraterritoriality.
Oh, looking at it, I agree with you because like the wording of the business operator in section 58, it specifically defined that it is a business operator in Thailand, but whereas like business operator in other sections, it doesn't mention that it has to only be exclusively a operator in Thailand. So yeah, maybe we can use the FX doctrine with other sections of the Trade Competition Act.
Yeah, I mean, I think that's something to explore, right? There are two alternatives here. If you want to leave it so blurry like this, then you can and you do it in practice, right? I mean, as a competition commission, or you can do what the Korean did, which basically amend the law and put it explicitly, right?
I think
this,
okay, so there's also an interesting point. Like I like during my internship, I was researching some Korean law, and according to like the people I was working with, they said that the Thai Competition Act was based on the Korean Competition Act. So like the interpretation of the Thai Competition Act can be like based on how South Korea or the KFTC decided too. So like all the cases, all those things can be taken into consideration because they share the same object and purpose, that sort of thing. So if like logically speaking, if whatever this person has told me is correct, um, if Article 2.2 of South Korea allows for extraterritorial application according to the effects doctrine, then there's a high tendency that because the Thai competition law is basically adapted from South Korea's, would also allow for effects doctrine.
yeah, I mean, I doubt that, because normally when we legislate any law, we just copy from everywhere. Not one country.
Yeah, that's also true. But yeah, when I was doing the internship, they said like it's
Melting pot of all good
based
things.
on South Korea.
Yes, but I mean, we were hugely influenced by Korean competition law. That's what I know as well. Yeah. But I mean, the background to this case is so important because if you look at the Korean economic development, especially when they had this miracle decade in the late 20th century, the main industry that they used as a springboard was the steel and shipbuilding industries, and that is where they export a lot of these products around the world, and then the money that they got, they sort of redirected, rechanneled this money to more sort of sophisticated industries, right? Samsung and all these more high tech industry were hugely subsidized during the period, and that was mainly, I think, and I think should be correct, was mainly the reason why they dared to exercise this effect doctrine. And you can see here that this is not purely competition, but it is more about industrial policy. Because to them, these steel and shipbuilding industries are really essential for that development. And if the costs are high, then they could be in trouble, right? Because these are the main cash cow for them. They produce, they generated a lot of money from these industries, and with the abnormally high level of costs, that would basically, I mean, that would I think that would be constrained to their development policy as well, right? So I think it is not just, when you talk about competition, it is not purely competition, because if you remember, in the first lecture, what I try to point out is that competition is not standing alone, and even competition policy itself, competition law itself has so many objectives, right? For example, when we talk about this horizontal agreement, the question is, how could OPEC survive when all these international cartels were hunt and demolished? But how could OPEC survive? I mean, they're super strong, and they are by definition international cartels, hardcore cartels. right? How could OPEC survive? What do you think? And international graphite electrode doesn't.
That's a hard question.
What do you think? Because the US can do everything, right? Because the US is the first one who adopted the effect doctrine. And the most powerful economic in the world. Maybe not for long, but why can't they do anything with OPEC? They don't even have to apply the effect doctrine because they're part of it.
Well, maybe OPEC has like a justifiable reason for existing.
But is this double standard? Because when it comes to domestic cartel, you say it's illegal per se. So why is something that illegal per se and potentially harms the economy, the domestic economy, turns out to be justifiable when it is in the international arena? Why is it? Or is it just something bad ongoing in the world? What do you think?
I mean, does OPEC has like that high of a anti-competitive effect?
I think OPEC is like positioned in a way that it seems. I mean, I don't know like much details about OPEC, but I think it's established in a way that seems like some kind of regional cooperation, like the same way ASEAN is, and a lot of like economic cooperations coming together for bargaining power. So like in the eyes of the international community, it looks more romantic.
Well, you cooperate internationally to do what? Basically, you cooperate on providing some support, or it's going to be something that basically you exchange some sort of like benefits or treatments, or the way that, I mean, all of you together would do something in the sense that you may provide internal benefit to each other, right? In the sense that you maybe you decrease the tariff, or you revoke some non-tariff barriers and those things, right? So
isn't that just the general nature of multilateral agreements, especially those concerning free trade already? Like the exchange of benefits and reciprocity. So you're saying that because it is limited to such group, it becomes a cartel?
but OPEC, I mean, whatever they do is not limited to their own group, right? But it affects everyone in the world. Because what they do is essentially the main activity is to set the oil price through the fixation of supply, right? We're going to produce this amount of oil in the next quarter. And that's essentially cartel by definition. So how could they survive? Or if they are justifiable, what is the justification?
Maybe world security. It sounds so romantic, but yeah.
Yeah, because if there wasn't, maybe if there was an OPEC, then there's a high tendency that oil prices could fluctuate a lot, and it will like damage the global economy.
Yeah, that's actually the main reason. The energy security. which is, I mean, it sounds a bit ridiculous, but at the same time, it also makes sense, right, to some extent, because if you consider this energy sector in Thailand, it has its own regulator as well, right? ERC, and one of the main reasons is, this is why I asked about the objective of competition law. Right, I'm drafting the competition law for the energy sector at the moment, and the main concern is that, well, there is this sort of like security in terms of energy that, I mean, pretty much all sectors, all economic sectors rely heavily on it. And you need to sort of a stability in the energy production, right? Because if there's any shortage, you look at Texas, right? Texas rely on their own energy like almost 100%, and when something happened, basically there was a disaster. So that is the energy security. But again, whether it's proportionate or not, that's another question, right? Do you really need to have that cartels and fix and control everything, or you actually can have some milder mechanisms by which you can ensure stability, but at the same time you can guarantee some certain level of efficiency as well, right? So and eventually it's, I think I used to ask, and I think all of you in the international law major, right?
We're in the business.
Or in business.
Yeah.
Because this is a mandatory course for the business. Sorry, that's another course. Yeah, it's in my mind. Yeah, the thing is, when you talk about this international thing, is it boils down to politics more than law, or it's basically a jungle rule, right? Okay. I think it's about time. I could talk about this all day long because I mean, this is my PhD thesis. I mean, this cartel thing, and it's super interesting. And my supervisor is Korean, so essentially, this is like a big part of my life. Yes. Okay, so I'll see you the week after the midterm, right? And we're gonna talk about merger. So you could catch some breathe. So that's good. All right. So good luck with your midterm exam, and I'll see you in 2 weeks' time.
Okay. Thank you.
Thank you.
Bye.
Great session today.
Thank you.
It's very fun.
Yeah, really interesting.
Bye bye.
Bye. Have a good day.
You too.